Chapter 5. Establishment of Support Obligations. Introduction. This chapter discusses several legal and practical issues that confront the 4D attorney who is presented with a case in which no support order has been established. For the purposes of this chapter, it will be assumed that paternity is not an issue or that a non-paternity defense may be disposed of through on a legal presumption of paternity or estoppel theory. For a full discussion of paternity, see Chapter 10. The first section discusses the developing trend toward use of formulas and other objective criteria for determining current support amounts. The Child Support Enforcement Amendments of 1984 require each state to establish guidelines for determining child support award amounts within the state. The second section discusses support in the form of medical benefits in lieu of, or in addition to, the more conventional financial monetary amounts. The third section covers jurisdiction for statutory claim for temporary and current support. The fourth section discusses claims by a state for reimbursement of support provided to an absent parent's family during a period in which no current support order was in effect. Temporary orders are discussed briefly in the fifth section. The sixth section surveys defenses that absent parents often assert to avoid the entry of a current support order. A discussion of modifications concludes the chapter. Guidelines. In theory at least, all states determine a parent's support obligation by balancing three factors: the needs of the children, the financial situation of the custodial parent, and the absent parent's ability to pay. However, as of August 1983, some 29 states had no statutory declaration of the factors a court should consider in entering a current support order. This is despite 45 CFR 302.53, a 1975 regulation mandating states to establish a formula for determining support amounts where no order exists. In such jurisdictions, the decision as to how much a parent should pay for child support is left entirely to the subjective evaluation of the court. At least 2 studies have suggested that child support obligations established in such jurisdictions are inconsistent and generally insufficient to meet the needs of the children. In an attempt to increase the credibility and use of objective criteria, a provision in the Child Support Enforcement Amendments of 1984 requires each state to establish, by October 1987, guidelines for determining child support award amounts within the state. Under 42 U.S.C. 667, states must establish such guidelines by law or by judicial or administrative action, and make the guidelines available to all judges and other officials who have the power to determine child support awards within such state. The federal statute does not require that the guidelines, once established and distributed, be binding on these judges and other officials, nor does it suggest methods for developing the guidelines. Oakes has made the requirement more specific by promulgating 45 CFR 302.56, c, which reads, "The guidelines must be based on specific descriptive and numeric criteria and result in a computation of the support obligation." Perhaps to focus the court's analysis of the support issue, the Uniform Marriage and Divorce Act, Section 309, instructs the court to consider a set of subjective criteria, in addition to all relevant factors, as follows: the financial resources of the child, the financial resources of the custodial parent, the standard of living the child would have enjoyed had the marriage not been dissolved, the physical and emotional condition of the child and his or her educational needs, the financial resources and needs of the non-custodial parent. Oakes followed suit in 1975 by promulgating a regulation that mandated each state child support enforcement agency to establish a formula for determining support amounts where no order exists. 345 CFR 302.53 requires the formula to take the following factors into account: all earnings, income, and resources of the absent parent including real and personal property, the earnings potential of the absent parent, the reasonable necessities of the absent parent, the ability of the absent parent to borrow, the needs of the child for whom support is sought, the amount of assistance that would be paid to the child under the full standard of need of the states for a plan, the existence of other dependents, other reasonable criteria that the state may choose to incorporate. The federal regulation does not require state courts to use the formula when establishing support orders. As a result, the regulation has had little effect. except in states that use an administrative process to establish support obligations. Several attempts have been made to develop objective guidelines that result in predictable, consistent, and equitable support amounts. Judith Cassetti and Frank Douthit provide a good discussion of this topic in The Economics of Setting Adequate and Equitable Child Support Awards. The discussion of guidelines here is based on this article. According to Cassetti and Douthit, there are three basic approaches to allocating the support responsibility between parents who do not reside in the same household, as follows: the cost-sharing approach, the taxation approach, the income-sharing approach. Each of these approaches is discussed below. Cost-sharing approach. The cost-sharing approach centers on the cost of raising the children involved in a case and allocates responsibility for that cost between the two parents based on their relative abilities to contribute. One example of a formula that adopts the cost-sharing approach and that has received a significant amount of attention in recent years is the formula espoused by Maurice Franks, a family law specialist in Colorado. Franks suggests the following formula. Please read the PDF or document. In jurisdictions that have adopted this approach, such as the state of Oregon, the court generally assumes that the custodial parent is meeting his or her obligation by maintaining the primary home of the children, meeting their recurring needs, and perhaps incurring daycare or babysitting expenses in order to work outside the home. After making this assumption, the court orders the absent parent to contribute the amount dictated by the formula, in our example $461.40. The custodial parent's share is assumed to make up the difference between the absent parent's contribution and the actual month-to-month needs of the children. This approach is effective for allocating the support responsibility in situations, such as the above, where the parents are both employed and making modest to slightly above average incomes. The cost-sharing approach is not effective where the absent parent's income is significantly below or above the middle range. For low-income absent parents, the cost-sharing approach does not resolve, nor purport to resolve, the conflict between the children's demands on the absent parent's income and his or her need to retain a minimal amount of income for self-support. The other significant defect is that the focus on need can operate to place a cap on the amount which is ordered. If the needs of the children are determined to be $769 per month, based on the standard of living enjoyed by the family during the marriage, then the absent parent's support obligation cannot exceed that amount, no matter how high his or her income. Most jurisdictions make an upward adjustment by assuming that children's needs are elastic, and that they increase in a positive proportional relationship to the available income. The cost-sharing approach certainly does not prevent adjustments to account for low and high incomes, but neither does it suggest how to make such adjustments. Taxation approach. The taxation approach takes its name from its resemblance to income tax tables and from proposals in Wisconsin and California to implement collection of child support through the state income tax structure. The approach relies on tables which dictate the amount of child support as a percentage of the absent parent's income. For example, the state of Illinois recently enacted several identical statutes that dictate the amount of support to be awarded in various support proceedings. These statutes read as follows. The court shall determine the minimum amount of support by using the following guidelines. Please read the PDF or document. In cases wherein health/hospitalization insurance coverage is not being furnished to dependents to be covered by the support order, the court shall order such coverage and shall reduce net income by the reasonable cost thereof in determining the minimum amount of support to be ordered. The above guidelines, including dependent health/hospitalization insurance coverage, are binding in each case unless the court makes express findings of fact as to the reason for the departure below the guidelines. The guidelines may be exceeded by the court without express findings or by agreement of the parties. If the total gross income cannot be determined because of default or any other reason, the court shall order maintenance or support or both in an amount considered reasonable in the particular case. Debts owed to private creditors are not to be considered in establishing a support obligation. Previous support orders and maintenance orders may be considered if the obligor is paying them. Emphasis added. The taxation approach focuses on ability to pay and assumes that all children have minimum needs that comprise a constant percentage of the absent parent's net income. Where a child has additional financial needs, the custodial parent must convince the court to deviate above the guideline amount. The statute makes it difficult for the court to enter an order in an amount lower than the guideline by requiring express findings to support such an order. This approach has several clear advantages and a few less obvious disadvantages. By defining net income as gross income less a list of specific allowable deductions, the statute standardizes and simplifies the process of applying the guideline to each individual case. For instance, the great majority of cases will no longer require evidence regarding the actual expenses incurred by the custodial parent for the support of the children. The court, in effect, can take judicial notice that the needs of the children bear a direct relationship to the absent parent's net income. Similarly, due to the statute's reliance on standard tax rates, the federal and state income taxes actually withheld from the absent parent's paycheck are not relevant. In addition, the prescribed list of deductions, in combination with the last paragraph of the statute, prevents any dispute as to the effect of other debts owed by the absent parent. One drawback of the Illinois statutes concerns the dependent health/hospitalization insurance coverage. The statute does not specify the level of coverage the absent parent is to provide, and yet the court must have evidence of the cost of the coverage in order to apply the formula. Such a situation may present difficulties to attorneys in cases where the level of coverage and cost cannot be stipulated prior to a hearing. The attorneys will need to present evidence of the cost of health insurance coverage but will not know in advance of the hearing what level of coverage the court will require. Presumably, judges will set a precedent over time that will allow attorneys to anticipate the appropriate level of coverage. This practical problem points out that practicing attorneys need to participate in the initial drafting and subsequent revision of support guidelines. Taxation approaches have two additional disadvantages. One involves the underemployed absent parent. Strict application of the statutory percentage to the low-income obligor may provide neither adequate support for the children nor sufficient income for the absent parent. Also, such guidelines, though intended to be minimum support contributions, may in practice become a ceiling on amounts awarded. Income sharing approach. The income sharing approach assumes that parents should continue to share the economic function of parenting to the fullest extent possible, despite the breakup of the family household. Income sharing formulas, therefore, seek to go beyond the children's minimum needs. An additional component allows for the sharing of surplus available income on an equitable basis. Cassetti and Douthit provide the following formula, again assuming a two-child situation. An absent parent who has not remarried and lives alone with a net income of $1,500 per month, and a full-time custodial parent with a net income of $1,000 per month. The numerator of this formula calculates the amount of surplus income available to the two-household family after covering all four individuals' minimum needs. The poverty level figures are estimates drawn from reports by the U.S. Department of Agriculture and the U.S. Department of Labor. The denominator represents the total number of individuals to be supported in both households. The resulting figure represents a per-person share of the surplus income. The child support amount would be $585 per month, 3 shares of surplus income. The income sharing approach has several advantages. Most importantly, it accounts for some variances both in need and ability to pay, the only approach of the three that can claim to do so. It accounts for the realities of the low-income obligor by granting a minimum needs allowance before requiring a support contribution. The court presumably could impute income to an underemployed obligor. The reliance on poverty level figures again replaces the need to adduce evidence as to the actual costs of supporting the children, and allows the formula to be adjusted by region or for the disparate costs between urban and rural life. The income sharing approach is perhaps best at taking into account household economies of scale and changing financial conditions over time. Once the formula is applied to a case, modification proceedings often can be avoided by simply reapplying the formula and stipulating to an order based on the new end result. Guidelines in the appellate courts. A body of appellate case law is developing regarding the legality and desirability of mandatory and advisory support guidelines at the state and local levels. The emerging rule is not unanimous, but appellate courts have been approving the concept. For instance, in Smith v. Smith, 290 or 675, 626 P2D 342, 1981. The Oregon Supreme Court studied the methods courts in that state used to award child support. The court noted that most of the state's courts employed a case-by-case approach, and that the appearance of uniformity among support orders is lacking. Supra, p. 345. The decision noted that this lack of uniformity causes a greater percentage of cases to require court hearing to establish a support amount, that settlements, even when successful, are more difficult to achieve, and that more cases are appealed than would be in a system with certainty and predictability. In discussing the adoption of a statewide formula approach, the court first rejected the use of the support regulation developed by the 4D agency as being exclusively appropriate for low-income level custodial parents with full-time physical custody. See OR 137-50-010. Apparently the court wanted to develop a more flexible approach to allow for its use in shared physical custody situations and multiple income situations. Next, the court rejected use of the schedule or percentage approach, similar to the taxation approach discussed above, because it does not take into account the custodial parent's income. The court further concluded that a schedule or percentage approach does not work well in cases where the absent parent's income is very high. The court noted that the costs of raising children do not increase at a constant rate with increasing parental incomes, especially above about $2,000 per month. The court felt that these deficiencies are best minimized by a formula approach, tempered by the trial court's discretion. The formula chosen by the court was the cost-sharing formula proposed by Morris Franks, C86 Case and Comment 3, 1981, and the discussion above. After the court has received a petition for support, see Exhibit 5.1, it applies the formula to the facts of the case. The trial courts in Oregon now are directed to adjust the support amount after considering the following factors: the interrelationship of child support with the division of property and spousal support, the indirect forms of child support, including payments for medical care, life insurance in the child's name on the parent's life, a trust for the child's education, insurance for hospital, medical or dental expenses and so forth, the income of the domestic associate or present spouse of each parent, the amount of assets of each parent, including the amount of equity in real or personal property. The existence of any support obligations to other dependents of each parent. The special hardships of each parent. In Hamilton v. Hamilton, 290 SE 2D 780, N.C.App. 1982, the North Carolina Court of Appeals stated, in dicta, as follows: the court wishes to lend its approval to the employment of guidelines by many trial courts and to encourage their use by others. A review of the case law underscores the total lack of consistency in the amounts of child support awarded by the courts. Moreover, the route by which the court arrived at a particular award is too often impossible to fathom. We concede that each domestic case is unique and that there must be an element of judicial discretion in setting the amount each parent should contribute to the support of his or her children. Such discretion, however, should not be unfettered. Employment of a standard formula would take into account the needs and resources of the parents, as well as the needs of the children, and would result in fair apportionment of responsibility in the majority of cases. While many others might not fit neatly into the established guidelines, the formula would provide a starting point for negotiations or formulation of judicial remedies. In cases where the trial judge determines, in his discretion, that considerations of fairness dictate a substantial departure from the standard award, we would recommend strongly that the court set forth specific findings of fact in support thereof. This would provide appellate courts with something more than the skeleton findings and conclusions on which we must often base our review of support orders. Likewise, the Supreme Court of Pennsylvania recently held that a formula approach is preferable to a system that simply refers to numerous general principles embodied in case law and subjectively worded statutes. Melzer v. Witzberger, 488 UD 991, Pa. 1984, in Melzer, p. 994, The court noted that there is a total lack of organization with respect to how these principles interact and how they should be applied in order to arrive at an appropriate award of support. The decision responded by requiring Pennsylvania courts to apply an adjusted cost-sharing formula to each case, after first determining the cost figure based on evidence of the children's needs, and the needs, customs, and financial status of the parents. The adjustment allows both parents to deduct their reasonable living expenses from their net incomes, prior to applying the cost-sharing formula to determine their respective support obligations. Thus, the formula adopted by the court is as follows. After calculating the respective total obligations, the trial court is to determine what portion may be met by support provided directly to the child, and enter an order requiring the absent parent to pay that amount on a regular basis. In Back v. Back, 351 NW 2D 387, Minnesota. App. 1984. The Minnesota Court of Appeals held that neither the fact that the absent parent's monthly living expenses exceeded his income nor the fact that his relationship to the child was by way of adoption justifies a trial court's deviating from the Minnesota mandatory guidelines. Minnesota.stat. Seconds 518.551, subbed. 5, sup. 1983. The guidelines themselves were approved as being applicable to non-public assistance child support cases in Halper v. Halper, 348 NW 2D 360, Minnesota.ct.app. 1984. One appellate decision holds that guidelines developed locally may not be used without giving the absent parent an opportunity to review or challenge them. Powell v. Powell, 433 So 2D 1375, fla.app.2D dist. 1983. The Powell Court held that their use violates both a state statute that prescribes a court's resort to extrinsic documentary evidence and a state statute that requires the court to balance all equitable principles and factors in reaching its decision regarding child support. Establishing need. Public policy as embodied in the guideline requirement of the Child Support Enforcement Amendments of 1984 dictates that support obligations fairly reflect a balance between the needs of the family and the absent parent's ability to pay. Given that the goals of the 4D program include both offsetting the cost of the AFDC program and helping all single-parent families to become more self-sufficient, this philosophy hardly can be disputed. Unfortunately, the practice in the program often has been less than successful in meeting this objective. For instance, an unpublished study by the Missouri Division of Family Services for the Missouri Legislature in 1982 indicated that the amount of the average support order in 4D cases in that state actually declined during the first 5 years of the program, despite inflation and a prioritization system which selected cases according to ability to pay. Attorneys in the program bear a great responsibility to use the resources and remedies at their disposal to ensure that courts have sufficient information to strike an appropriate balance, and to present information in a straightforward, usable manner. Many jurisdictions use the AFDC grant amount as a guideline and suggest that the court aim for that amount in setting its order. This approach not only violates the federal regulations, 45 CFR 302.53 and 302.56, it ignores the fact that, in many states, AFDC grant amounts are based on a percentage of the full standard of need established by the state agency to estimate the minimal financial needs of a child. The full standard of need amount, when updated for inflation, might prove a better guideline for the average child and might represent an acceptable criteria under the federal regulations. However, using it one clearly ignores the living circumstances of all the parties involved, and does not take into account the absent parent's ability to pay. As noted above, some jurisdictions have built standardized need estimates into their objective formulas. In such jurisdictions, it is necessary to adduce evidence regarding the children's needs only where they have special needs or where the attorney is asking the court to enter an order that deviates from the formula. It might be possible to use similar need estimates in jurisdictions that have yet to develop guidelines by laying a foundation for introduction of published government studies into evidence. Unfortunately, in most jurisdictions, an expert witness must lay the foundation, making the procedure too cumbersome. In the short run, attorneys in most jurisdictions will have to fill the record with testimony from the custodial parent regarding recent relevant expenses. Court rules in some jurisdictions require that all parties to support hearings submit financial statements, in the form of affidavits, before requesting a hearing date. By local practice, once such a rule is established, the testimony of the parties becomes structured around the affidavit, and the financial information is presented to the court in the same manner in every case. Such a practice makes determination of the obligation much easier on the court, lessens the chance that an item of evidence will be omitted mistakenly by counsel for one of the parties, and adds some predictability to the outcome. Even where there exists no mandatory statute or rule, the practice can be instituted voluntarily by the 4D attorney simply through consistent usage. An example of an affidavit that could be used in such a manner is included in the appendix to this chapter as Exhibit 5.2, establishing ability to pay. Most families who receive support enforcement services from the 4D program lack significant financial resources. As a result, the absent parent's ability to provide financial support generally will be the most important determinant of the support award. Therefore, it is crucial to obtain accurate and complete information regarding the absent parent's present and past financial situations. In determining the financial condition of the absent parent at the time the order is entered, most courts will take into account past and present earnings, and anticipated earning capacity in the future. Penkovic v. Penkovic, 45 calories. 2D 97, 287 P2D 501, 1955, in remarriage of Vinet, 544 SW2D 236, Mo.App. 1976. A court may base its order on what the absent parent could earn by using his or her efforts to obtain employment suitable to his or her capabilities. Foster v. Foster, 537 SW2D 833, 836, Mo.App. 1976. Congress and state legislatures have made some very effective information sources available to program investigators, but the income and asset information rarely comes in a form which is admissible as evidence in court. Thus, the 4D attorney must develop routine methods of obtaining such information in submissible form. As noted in chapters 4 and 10, this often involves the use of discovery devices. A set of form interrogatories is included in the appendix to chapter 4. See Exhibit 4.1. While interrogatories may not be feasible in every case, especially where the absent parent is not represented by counsel, a set of thorough interrogatories still can provide an effective interview and cross-examination outline. Perhaps the most important technique for guaranteeing that complete and accurate information is available in most cases is to make liberal use of subpoenas duces tecum to employers and other information sources. Mere reliance on pay stubs can be misleading. Pay stubs often do not reflect benefits which are not paid in cash, such as membership in prepaid medical, dental, and optical programs, and other forms of insurance that should be taken into account in determining the amount of the obligation and in fashioning the medical support portion of the order. Many program attorneys routinely subpoena bank account records. The flow of money through a checking or savings account is often a better indication of an individual's income than more conventional sources, which can be difficult to identify. Another good source is tax returns for past years, which in most states are discoverable. 70 ALT 2D 240, 1960, 1978 Sup. Medical Support. Section 16 of the Child Support Enforcement Amendments of 1984 requires state 4D agencies to pursue medical support in addition to financial support. Federal Statute 42 U.S.C. 652F directs the Secretary of Health and Human Services to issue regulations requiring the states to petition to include medical support as a part of any child support order obtained by the agency, whenever health care coverage is available to the absent parent at reasonable cost and the custodial parent does not have satisfactory health insurance coverage for the children. Regulations at 45 CFR 306.51a define reasonable cost as the cost of employment, related or other group health insurance. The conference report on the Child Support Enforcement Amendments of 1984 included a strong statement of public policy behind the requirement as follows. The conferees believe the best long-run solution to achieving medical insurance coverage for all families is the use of private medical insurance which is or can be made available through a parent's employer. The conferees direct the Secretary of HHS to examine additional administrative, regulatory and legislative possibilities to fully and vigorously use this private coverage, and report to the Finance Committee and the Ways and Means Committee by January 1, 1986 on actions taken. The new provision of the law clearly views providing for the medical needs of the child as an integral part of a parent's duty to support. While medical support may take other forms in specific situations, medical insurance is preferred because it is relatively inexpensive for the absent parent, provides for the needs of the child, and is easy for the state to monitor without additional and costly case-by-case modification. Providing private insurance coverage for children who otherwise would depend on Medicaid will reduce the public costs in supporting these children and result in significant Medicaid cost savings for state and federal governments. In addition to the requirement to obtain medical support orders, the Social Security Act contains provisions at 42 U.S.C. 1302 and 1396, K, allowing the State 4D agency to assist the state Medicaid agency in enforcing medical support obligations. The accompanying regulations at 45 CFR 306, Subpart A, provide for an optional cooperative agreement between the two agencies. Under a cooperative agreement, the 4D agency agrees to perform one or more of the following activities for cases in which Medicaid has secured an assignment of medical support rights. Receive referrals from the Medicaid agency. Locate the absent parent, using the State Parent Locator Service and the Federal Parent Locator Service, as needed. Establish paternity if necessary. Determine whether the parent has a health insurance policy or plan that covers the child. Obtain sufficient information about the health insurance policy or plan to permit the filing of a claim with the insurer. File a claim with the insurer. Transmit the necessary information to the Medicaid agency or to the appropriate state agency or fiscal agent for the filing of the claim, or require the absent parent to file a claim. Report to the Medicaid agency, in the most efficient and cost-effective manner available, all information collected pursuant to 45 CFR 306.5, A, and B1. Secure health insurance coverage through court or administrative order when it will not reduce the absent parent's ability to pay child support. Take direct action against the absent parent to recover amounts necessary to reimburse medical assistance payments when the absent parent does not have health insurance and the amounts collected will not reduce the absent parent's ability to pay child support. Receive medical support collections. Distribute the collections as required by 42 CFR 433.154, including calculation and payment of the incentives provided for by 42 CFR 433.153. Perform other functions as may be specified by instructions issued by OACS. The federal regulations also set forth administrative requirements that must be met through the cooperative agreement entered into by the agencies. They also require that the Medicaid agency fully reimburse the 4D agency for the latter's medical support enforcement activities under the agreement. Jurisdiction. Actions that seek to obtain a support order against a parent are in personam actions, and the court must obtain jurisdiction over that parent by personal service of process pursuant to state statute or rule. In Re Johnston, 33 Wash.App. 178, 653 P2D 1329, 1983. The statute or rule which allows for service must meet the due process notice requirements established by the U.S. Supreme Court in Mullane v. Central Hanover Bank and Trust, 339 U.S. 306, 70 S.E.T. 652, 1950. The state also must possess the minimum contacts defined by International Shoe v. Washington, 326 U.S. 310, 66 S.E.T. 154, 1945, such that the exercise of jurisdiction over the defendant does not offend traditional notions of fair play and substantial justice. What do these standards mean when applied to the establishment of child support obligations? Most states have adopted a statute or court rule that extends state court jurisdiction in a divorce action to spouses who reside out of state if the parties to their marriage lived in the state immediately prior to their separation. See, for example, Wisconsin. Stat.Ann. Seconds. 247.57, Can.Code Sif. Proc. Seconds 6308, subbed. B. If the facts meet the requirements of the statute, or if the absent parent's contacts with the state are clear and the state has a general long-arm statute that could form the basis of the court's jurisdiction, then it should be possible to obtain jurisdiction over him or her by way of extraterritorial service of process. In the absence of some clear, recent connection between the absent parent and the forum state, it is difficult for a state court to exert jurisdiction over an absent parent to justify the entry of a support order. The Supreme Court ruled that neither the fact that the parties were married during a brief visit to the forum state nor the fact that the defendant allowed the children of the marriage to reside in the forum state constitutes acceptable minimum contacts under the International Shoe Test. Kulko v. Superior Court, 436 U.S. 84. 98 S.E.T. 1690, 56 led 2D 132, 1978. More significant than the specific holding in the case was the attitude that the court took in restricting extraterritorial jurisdiction in the child support context. The existence of an action under EURASA was noted as a less restrictive alternative that protects the state's interest, that is, providing a remedy for the support of the state's children, without causing a hardship on the out-of-state absent parent. This language does not bode well for future attempts to expand the jurisdiction of state courts in establishment cases. However, in Miller v. Kite, 318 SE 2D 102, N.C.Ct.App. 1984. The court held that a father's allowing a child to reside in North Carolina for 9 years and benefit from public education constitutes sufficient minimum contacts to confer jurisdiction over him for purposes of establishing a child support obligation. Likewise, in re Highsmith, NE 2D, 11 Floor 1247, 3. 1985. The Illinois Court of Appeals held that an absent parent who dumps a child with its grandparents and then leaves the state possesses sufficient contact with the state to allow for jurisdiction. Some statutes and older decisions would support the entry of a support order based on in rem jurisdiction, that is, jurisdiction over the defendant based on seizure of an item of real or personal property owned by the defendant and located within the territorial jurisdiction of the court. See, for example, Jenkins v. Jenkins, 246 Pascals. Super. 455, 371 A2D 925, 1977, since the U.S. Supreme Court's decision in Sheffer v. Heitner, 97 S.E.T. 2569, 53 led 2D 683, 1977, in rem jurisdiction is limited to actions concerning the piece of property seized. Because it is logically impossible for this condition to apply to the child support establishment process, it is unlikely that in rem jurisdiction is an option. Jurisdiction over military absent parents. Frequently, a child support enforcement attorney must obtain a support order against an absent parent who is serving out of state in the military or who fails to respond to service of process within or without the state. Before moving for entry of a default judgment in such situations, the child support attorney should consult the Soldiers and Sailors Civil Relief Act of 1940, as amended, 50 U.S.C.S. Apps. Seconds 520. The Act establishes certain duties and obligations on plaintiffs, courts, and defendants in legal proceedings, including actions to establish support, and creates certain rights and remedies for defendants. It provides as follows. Sec. 520. Default judgments affidavits bonds attorneys for person in service. 1. In any action or proceeding commenced in any court, if there shall be a default of any appearance by the defendant, the plaintiff, before entering judgment, shall file in court an affidavit setting forth facts showing that the defendant is not in military service. If unable to file such affidavit, plaintiff shall in lieu thereof file an affidavit setting forth either that the defendant is in the military service or that plaintiff is not able to determine whether or not defendant is in such service. If an affidavit is not filed showing that the defendant is not in the military service, no judgment shall be entered without first securing an order of court directing such entry, and no such order shall be made if the defendant is in such service until the court shall have appointed an attorney to represent defendant and protect his interest, and the court shall on application make such appointment. Unless it appears that the defendant is not in such service, the court may require, as a condition before judgment is entered, that the plaintiff file a bond approved by the court conditioned to indemnify the defendant, if in military service, against any loss or damage he may suffer by reason of any judgment should the judgment be thereafter set aside in whole or in part. And the court may make such other and further order or enter such judgment as in its opinion may be necessary to protect the right of the defendant under this Act, Secs. 501 et sec. of this Appendix. Whenever, under the laws applicable with respect to any court, facts may be evidenced, established, or proven by unsworn statement, declaration, verification, or certificate, in writing, subscribed and certified or declared to be true under penalty of perjury, the filing of such an unsworn statement, declaration, verification, or certificate shall satisfy the requirement of this subdivision that the facts be established by affidavit. 2. Any person who shall make or sue an affidavit required under this section, or a statement, declaration, verification, or certificate certified or declared to be true under penalty of perjury permitted under subdivision 1, knowing it to be false, shall be guilty of a misdemeanor and shall be punishable by imprisonment not to exceed 1 year or by fine not to exceed $1,000, or both. 3. In any action or proceeding in which a person in military service is a party if such party does not personally appear therein or is not represented by an authorized attorney, the court may appoint an attorney to represent him, and in such a case, a like bond may be required and an order made to protect the rights of such person. But no attorney appointed under this Act, Secs. 501 et sec. of this Appendix, to protect a person in the military service shall have power to waive any right to the person for whom he is appointed or bind him by his acts. 4. If any judgment shall be rendered in any action of proceeding governed by this section against any person in the military service during the period of such service or within 30 days thereafter, and it appears that such person was prejudiced by reasons of his military service in making his defense thereto, such judgment may, upon application, made by such person or his legal representative, not later than 90 days after termination of such service, be opened by the court rendering same and such defendant or his legal representative latent to defend, provided it is made to appear that the defendant has a meritorious or legal defense to the action or some part thereof, vacating, setting aside, or reversing any judgments because of any of the provisions of this Act, Secs. 501 et seg. of the Appendix, shall not impair any right or title acquired by any bona fide purchaser for value under such judgment. As the language of the Act discloses, its duties and obligations arise whenever a plaintiff seeks to obtain a default judgment in a civil action. The rights and remedies apply whenever the defendant is in the military. Clearly, the Act's provisions apply in matrimonial actions. See Anno, Soldiers and Sailors Civil Relief Act, as amended, as affecting matrimonial actions. 54 Al. 2d 390, thus, before seeking a default judgment in a support action, the child support enforcement attorney must comply with the requirements of the Act. Where it is clear that the absent parent is not an active member of the military, the Act simply requires that an affidavit to that effect be filed with the court. Most courts have built this requirement into their routine default judgment procedures. Presumably, the affidavit may be sworn out by either the child support attorney or the custodial parent, depending on who signs the petition for support. If the defendant is in the military, The Act is more difficult to apply where the cause of action involves complicated issues and extensive trial preparation. The defendant's being in the military no doubt would adversely affect his or her ability to present a defense. The Act would require dismissal or a stay until circumstances change. However, the case law that has developed under the Act recognizes that such prejudice should not be assumed. It is well established that a trial court has wide discretion in determining whether a defendant's service in the military would undermine his or her ability to defend an action. 54 Al. 2d 392. The issue generally finds its way into the reported appellate case law after a defendant seeks to have a default judgment set aside and is refused relief by the court that entered the order. These decisions provide valuable guidance for courts at the trial level. As the above cited annotation points out, the Act does not delegate the burden of proof on the issue of adverse effect. In other words, the plaintiff need not prove that the defendant's service in the military will not adversely affect his or her ability to prepare for and defend the action. The court is to consider all the information available from either party in deciding whether or not to let the action proceed. Thus, the defendant is not entitled to a stay merely by filing a motion requesting relief. Cadiux v. Cadiux, 75 So 2d 700, Fla. 1954. Gates v. Gates, 197 Georgia 11, 28 SE 2D 108, 1943, Lux v. Lux, 245 Minnesota. 141, 71 NW 2D 850 54 Al 2D 384, 1955, where the court determines that the defendant would not be adversely affected by commencement of the suit. The Act requires the court to appoint an attorney to represent defendant's interests and authorizes the court to require the plaintiff to post a bond to indemnify the defendant against any loss or damage that the resulting judgment might cause. The court further is authorized to make other orders or judgments as necessary to protect the defendant's rights. Clearly, in some fact situations it is appropriate for the court to enter a default judgment or allow the action to proceed to judgment. After appointing counsel for the absent parent, a number of decisions have refused to set aside default judgments against military defendants, many involving divorce decrees that were not challenged until the plaintiff sought to enforce the support provisions. See for instance Crum v. Crum, 6 Can. App.2d 939. 636 P2D 814, 1981, Swartz v. Swartz, 412 So 2D 461, Fla.app. 1982. Moreover, a significant body of case law holds that a default judgment entered against a defendant in the military is merely voidable and not void. Radlinsky v. Superior Court of Santa Barbara County. 186 calories. App.2D 821, 9 calories. RPTR. 73, 1960, Courtney v. Warner, 290 So 2D 101, Fla. App. 1974, 35 ALF ed. 649. The Courtney case is particularly interesting. It holds that a default judgment entered by a Tennessee court is entitled to full faith and credit in Florida despite the defendant's allegation that the plaintiff in the Tennessee action did not comply with the Act. A defendant in a support action is not entitled to relief per se as a result of his military service. Nevertheless, because the Act was designed to prevent prejudice to military defendants, a plaintiff may have difficulty convincing a judge to proceed with a support action without the defendant's presence. The argument to the court should proceed as follows. The only relevant issues are the needs of the children and the absent parent's ability to pay. The needs of the children can be established at the hearing through the testimony of the custodial parent. If the absent parent has been away in the military for an extended period of time, in most cases he or she will not be able to contradict the custodial parent's testimony. The attorney appointed on behalf of the absent parent will be able to cross-examine the custodial parent to the same extent whether the absent parent attends the hearing or not. The evidence regarding the absent parent's ability to pay generally will have been obtained through his or her affidavit, answers to interrogatories, or the military discovery process. No matter what route is taken to obtain the evidence, the absent parent will have ample opportunity to review the information presented to the court and to prepare a counterposition should he or she disagree with the plaintiff's evidence. Thus, except in cases where the children have special needs or the absent parent has an unusual defense to the obligation, going forward with the hearing on a petition for support without the attendance of the military absent parent should not be prejudicial, as long as he or she is represented by counsel. Nationally, about 1/3 of new AFDC families are the beneficiaries of a current support order. Of the remaining 2/3, about half are cases in which paternity has not been established. Thus, about 1/3 of new cases involve children whose parentage is not in dispute but who, for a variety of reasons, do not have the benefit of an enforceable support order. This situation arises for several distinct reasons. Usually, the spouses simply have separated without benefit of court involvement. Perhaps they do not wish to finalize their dispute in a divorce. The state in which they made their marital home may make it difficult and expensive to dissolve a marriage, or the waiting period may be long and neither of the parties may be inclined to seek temporary relief or access to legal services. Alternatively, divorce may have been entered, but because the plaintiff spouse did not know the whereabouts of the absent spouse, the court was unable to enter a support order. Whatever the cause, the situation requires the establishment of a support order. Due to the excessive caseloads facing most state child support enforcement agencies, and the several months it can take to locate an absent parent, several $1,000s in AFDC and Medicaid benefits may be paid out prior to a case being referred for legal action. The issue for discussion here is there a legal remedy that allows the state to seek reimbursement of public assistance paid to an absent parent's family during the period prior to entry of the current support order? Statutory remedies. Several states authorize the 4D agency to establish enforceable support obligations through administrative notice and hearing processes. Administrative processes are discussed in detail in Chapter 8. Typically, such a statute will provide that, in the absence of a current support order, the payment of public assistance to or for an absent parent's child creates a debt due from the parent or parents in the amount of the AFDC provided. 137 other states, such as California, Kansas and Texas, 14, have created a similar obligation, which may be determined and enforced judicially. In many states, no statutory treatment of this issue exists, and the attorney must resort to a claim based on common law principles. The common law remedy. Blackstone frequently is quoted in support of the proposition that no civil action existed at common law for support of a minor child. 11 BL. Com. 449, Greenspan v. Slate. 12 NJ 426, 97 A2D 390, 1953. As the New Jersey Supreme Court points out in its decision in Greenspan, pp. 391-393, Blackstone's conclusion is not entirely accurate when applied to the common law as it developed in this country. As early as 1371, an action existed in the English ecclesiastical courts against the alleged father of an illegitimate child, both for current support and for reimbursement of sums the mother expended from her own estate in supporting the child. -5. During the same period, the law courts were applying an agency theory to require a father to repay third persons who provided necessaries to the father's legitimate children. In England, the evidence of agency or apparent agency had to be specific. Greenspan, Supra, p. 392, citing Mortimer v. Wright, 6M. and W. 482, Exch. Diff. 1840, and Shelton v. Sprinet, 11 CB 452, com. PL. 1851, both in England and in the United States. Common law allowed third parties to recover for necessaries provided to a man's wife. For this action, no showing of express agency was necessary. Many U.S. courts merged these two theories to create a cause of action on behalf of the mother, as well as on the behalf of third parties, for reimbursement of necessaries provided to children. These courts either inferred agency from very slight evidence, or acted as though the action existed in English common law without the agency requirement. See Freeman v. Robinson, 38 NJL 383, 384, Sup.ct. 1876, Penningroth v. Penningroth, 71 Mo.app. 438, 441, 1897. As a result, it is not always clear whether the decisions infer the existence of an agreement, or whether the agreement is merely a legal fiction the court employs to enforce the moral duty. There is also some confusion as to 11 whether the action is an action at laws or in equity. Whatever the nature of the claim, it is firmly established in a majority of American jurisdictions. 91 Al 3D 530, Fainelli v. Barkley, 100 Miscellaneous.2D 471, 419 S2D 813, 1979, Jenkins v. Jenkins, 246 Pascals. Super. 455, 371 A2D 925, 1977, Toy v. Cherico, 367 A2D 651, Del. Super. 1976, Franklin v. Julian, 30 Ohio Street. 2D 228, 283 NE 2D 813, 1972, Kalik v. Schrank, 179 Connecticut 283, 426 A2D 276, 1979, Dicta, recognizing that the action exists in New Jersey, Weinstein v. Weinstein, 148 So 2D 737, Fla.app. 1963, Dawson v. Dawson, 135 SW2D 458, Tennessee.app. 1939, Jameson v. Jameson, 306 NW2D 240, ST, 1981, Watkins v. Dudgeon, 270 Arc. 56, 606 SW2D 78, Arc. App. 1980, Brown v. Brown, 269 NW2D 819, Lower 1978, York County v. Johnson, 206 Neb. 200, 292 NW2D 31, 1980, Mobley v. Baptist Hosp. Of Gadsden, 361 So 2D 16, Alabama.sif.app. 1978, Fauntroy v. U.S., 413 A2D 1294, D.C. app. 1980, Allison v. Fulton D. Carl Hosp. Orf. 245 Georgia 445, 265 SE2D 575, 1980, Lane v. Aitnakaz and Zuerko, 48 NC. app. 634, 269 SE2D 711, Rev. Den. 276 SE2D 916, 1980, Marks v. Mitchell, 90 W.Va. 702, 111 Say 763, 1922, Hartley v. Ungvari, 318 SE2D 634, w.va.sup.ct.app. 1984. Under the common law theory, a claim for reimbursement of necessaries accrues against a child's father to any person who has provided the child with food, shelter, clothing, medical attention, or education. Hooton v. Hooton, 15 SW2D 141, text.sif.app. 1929, the cause of action looks to the past, not the future. In most jurisdictions, a statutory support order substitutes for the common law obligation, at least as to the children's mother. The statutory support order looks to the future and acts to limit any future recovery by the custodial parent to the amount of the order. Lodal v. Papenburg, 277 SW2D 548, Mo. 1955. The effect of an existing current support order on the claims of third parties varies from jurisdiction to jurisdiction. 91 Al 3D 561, as pointed out above, this discussion assumes no support order. The common law claim in the 4, D context. A claim for reimbursement of necessaries may be useful to the 4D agency in the following situations. An action is being pursued to establish a current support obligation, and the AFDC case has been open for a number of months prior to the filing of the support action. A paternity action is being pursued, and the AFDC case has been open for a number of months. The AFDC case that formed the basis of the 4D referral has closed, and the case promises good collection potential. An enforcement action has produced a collection, for instance, a federal tax refund interception, and the absent parent responds with a collateral attack, or other challenge, on the order which forms the basis of the collection. Some argue that the addition of the common law claim to a 4D agency's arsenal of collection weapons would have little effect. After all, it is difficult enough to collect current support from the majority of absent parents pursued by the 4D program. In addition, the burden of repaying the agency for past assistance often would limit the absent parent's ability to pay current support. Such an argument is misleading, however. Common law claims can strengthen the agency's negotiating position in every case and allow cases to be worked that would otherwise be shelved. The last two situations noted above are particularly good examples. The agency already has spent time and effort on these cases, and the common law claim may turn this effort into collections instead of frustration. In evidence of the usefulness of the common law claim in the 4D context, at least 3 state child support enforcement agencies have obtained appellate decisions which establish the vitality of the claim on behalf of the state. In State Division of Family Services v. Clark, 554 P2D 1310, Utah 1976. The Utah Supreme Court held that the state may recover amounts of public assistance provided in the past despite the lack of a support order for the period in question. The court noted that the parent's obligation is rooted in natural law as an implied promise contained in the marriage contract. The obligation runs to the children, but when a third party comes forward and assumes the parent's responsibility, that party becomes subrogated to the child's right and may obtain reimbursement. Clark, Supra, p. 1311, the court did not address the specific issue of whether the state may qualify as a third party under the common law rule, but simply assumed no impediment. The Montana Supreme Court also treated the issue in the case of state by and through Department of Social and Rehabilitative Services v. Hultgren, 168 Montana 257, 541 P2D 1211, 1975. There, the decision specifically held that the state agency that assumes the support responsibility qualifies as a third party under the common law rule and is entitled to reimbursement. Also see State Division of Family Services v. Hollis, 639 SW2D 389, Mo.App. 1982. In addition to making a claim against an absent parent under the third-party liability theory, it would seem to be possible to assert the claim through the custodial parent via the assignment of support rights required of all AFDC recipients by 42 U.S.C. 602(26). Elements of the cause of action. In the majority of jurisdictions, the elements of the cause of action are simple to allege and establish. At common law, the obligation ran to the father and simply stated that he was liable to reimburse any third party who came forward to supply reasonable and necessary support for his wife and/or children. The elements of the cause of action were as follows: paternity in the defendant, no court order for support entered by any court, his failure to provide support, provision of support by the plaintiff, necessity, reasonableness of the support provided. In the majority of states, the cause of action remains as set forth here, except that it presumably extends to claims against mothers as well as fathers, at least in states which have enacted an equal rights constitutional amendment. 91 Al 3D 530. However, courts in a few states have added requirements that create obstacles for the 4D programs, such as a requirement that the plaintiff first demand that the absent parent meet the obligation prior to assuming it and seeking reimbursement. Maxson v. Holmes, 269 SC 293, 237 SC 2D 363, 1977. A requirement that the plaintiff expect reimbursement at the time the necessaries are provided. Re Altman's Will, 149 Miscellaneous 115, 266 NIS 773, 1933. A requirement that the plaintiff show that the absent parent had the financial ability to pay during the period for which reimbursement is sought. Holt v. Holt, 42 Arc. 495, 1983. A requirement that the fault of the separation not be the custodial parent's. State Ex Rel. Division of Family Services v. Standridge, 676 SW2D 513, Mo. 1984. One other potential problem concerns the issue of the custodial relatives portion of the public assistance grant in those states that consider the needs of the custodial relative in the AFDC budgeting process. If the absent parent owes no duty of support to the custodial relative, it is arguable whether the absent parent has an obligation to repay the entire amount of public assistance. The counterargument here is that the eligibility for public assistance is based on the children, taking into account the needs of the custodial relative, and balancing those needs against the income of the custodial parent. The state simply is adjusting the amounts to be paid to the children according to the financial situation of the custodial parent. A court uses the same process to fashion a current support amount. The amount of the public assistance grant which is attributable to the needs of the custodial relative, when reviewed in this light, is no more for the custodial parent than would be the analogous portion of a judicial order for current support. The common law reimbursement for necessaries remedy still exists in a majority of American jurisdictions. It can increase the effectiveness of the 4D program by allowing the state or local jurisdiction to recover child support from a parent for a period of time in the past during which no support order was in effect. Also, it can increase the bargaining position of the 4D agency when negotiating the establishment of a current support obligation. A sample petition for reimbursement of necessaries appears in the appendix to this chapter as Exhibit 5.3. Temporary orders. Generally, temporary orders are appropriate for only a small portion of the 4D agency's caseload. Temporary orders occasionally can help expedite a divorce action. In such cases, an absent parent who has been contesting the action to avoid support payments loses any advantage he or she may have gained through delay. Temporary support orders also are important for securing current support when the state is expending money for the child, REN, and the divorce action is likely to be lengthy. Once the temporary order is established, it is subject to all appropriate enforcement remedies. A motion for temporary orders will come before a judge in one of two ways. Either the client's attorney will so move or the 4D attorney will intervene in the divorce action by filing a petition for temporary support. When intervening in a divorce, the 4D attorney will participate only in setting the amount of child support. In setting support for the temporary order, the judge is required to consider all relevant factors in the same manner as for a permanent support order. The absent parent's attorney may raise issues of temporary custody and visitation. 187. However, these issues should not be relevant to the support action. The 4D attorney should stress the limited purpose of the order, the child's best interest, and the interest of the state. One problem that can arise in pursuing temporary orders involves the unrepresented AFDC recipient who is being divorced by an absent parent. The 4D attorney should make it clear to the recipient, to the absent parent's attorney, and to the court, that the 4D attorney does not represent the recipient's interest in the divorce action. The AFDC recipient should be counseled to seek representation in the divorce action from legal services or the private bar. Under an equal protection argument, several states have begun to issue temporary support orders in paternity cases. Because the amount of the temporary order is often higher than the final order, this action often encourages early resolution. Temporary support in paternity cases is discussed in Chapter 10 of this handbook. It should be noted that the common law reimbursement for necessaries action, discussed above, also is available as an option to reimburse the state for monies paid out in AFDC for children for whom there was no established support order. Defenses to establishment. This section surveys a limited number of defenses that absent parents submit in establishment proceedings. Enforcement defenses are covered in Chapter 7. Defenses peculiar to interstate cases are treated in Chapter 9. Bad faith non-paternity defenses. On occasion, fathers of children who were born during their marriage to the mother will submit a defense of non-paternity for the purpose of gaining a negotiation advantage or making the proceeding as cumbersome as possible in the hopes that the 4D agency will drop the action. There are several rules of law which can be used to defeat such an attempt. Presumption of paternity. Where the child was conceived or born during the marriage, or during a marriage which was attempted but failed for technical reasons, the child normally is presumed to be the legitimate issue of the husband. In the interest of stabilizing family relationships, there is a universal, worldwide acceptance of a strong presumption of legitimacy in favor of children born in wedlock. The extent to which the presumption is rebuttable varies from jurisdiction to jurisdiction, and it is almost impossible for the father to raise in jurisdictions that still recognize Lord Mansfield's rule to prohibit a parent from giving testimony to bastardize a child born during the marriage. 20. In other jurisdictions, the presumption is rebuttable, but the party attacking the presumption generally has a difficult burden of proof to overcome. See, for example, AGV. SG. 199 Culloh. 403, 609 P2D 121, 1980, Gross v. Vanlerberg, 7 Can.Tap.2D 99, 638 P2D 365 reviewed 646 P2D 477, 1981, Smith v. Casey 198 Culloh. 433, 601 P2D 632, 1979. Legitimation by marriage. Even where the child was not born nor conceived during the absent parent's marriage to the mother, if a marriage follows the child's birth and the father acknowledges his paternity in writing, many states treat that child, for all purposes, as though it was born of the marriage. See Mixon v. Mize. 198 So 2D 373, Flat.App. 1967, Commonwealth v. Rosensky, 206 Pascals. Super. 397, 213 A2D 155, 1965, Missouri Family Law, 3rd edition, The Missouri Bar, 1982. Seconds 18.50. A state's probate code often treats this topic. Equitable estoppel or adoption. Even where the father never made an acknowledgement specific enough to bring into play one of the above, the father may be estopped from denying paternity where he has held the child out to the community as his, and the child has relied on this implied acknowledgement. See Watts v. Watts, 115 NH 186. 337 A2D 350, 1975, Drake v. Drake, 43 SW2D 556, Mo. 1931, Missouri Family Law, 3rd edition, The Missouri Bar, 1982, seconds. 18.51 The runaway child. The obligated parent may argue that when he or she is willing to provide a home for the child and the child voluntarily leaves that home, the parent should not be made to pay support. Nevertheless, these circumstances do not absolve the responsible parent of his or her legal obligation to pay child support. However, a noteworthy exception is when a court orders that the child shall not leave home without permission of the court. This is a common provision in many divorce decrees. In the case of Virgil v. Virgil, 494 P2D 809, Culloh. 1972, the fact that the mother had removed the children from Colorado without the father's consent did not relieve the father of his duty to support the children. Other cases hold that a parent may be found criminally responsible for his or her failure to support his or her child, even though the child is living apart from the parent without the parent's consent. Benfield v. State, 4 say 869, Georgia 1888, Moore v. State, 57 say 1016, Georgia 1907, Commonwealth v. Donovan, 220 SW 1081, Key. 1920, State v. Sutcliffe, 25 654, RI 1892, Beelfuss v. State, 126 NW 33, Wis. 1910, and Bowen v. State, 46 Northeast 708, Ohio 1897. Release agreements. Generally, an agreement between the parents of a child made outside the courtroom which absolves the non-custodial parent's support obligation is invalid. In Remarriage of Goodrich, 622 SW2D 411, 413, Mo.App. 1981, Story v. Ward, 258 Arkansas 24, 523 SW2D 387, 1975, Elkin v. Bike, 67 California, UPTR. 404, 439 P2D 316, 1968, Barnett v. Barnett, 243 A2D 51, D.C.App. 1968. Most courts hold that parents cannot bargain away the children's right to continuing support in accordance with their needs and the parent's ability to provide support. This is true even where the agreement is contained in a previous settlement which was incorporated into a divorce decree. Williams v. Williams, 542 SW2D 563, 566, Mo.App. 1976, Hart v. Hart, 539 SW2D 679, 682, Mo.App. 1976, Keys v. Keys, 9 P2D 804, Idaho 1932. However, in some jurisdictions, the custodial parent can release his or her title to both past and future support but cannot release support belonging to the children. Rule v. Rule, 74 NW2D 689, Neb. 1956. Modifications. Many child support orders have been rendered insufficient by the passage of time and the effects of inflation. Others no longer correspond to the real ability of the absent parent to pay support. The authority of the court to modify child support obligations has been addressed in several decisions, universally affirming the discretion of the court to modify its own orders. The Child Support Enforcement Amendments of 1984 require as well that every issued or modified order include a provision for mandatory wage withholding. 45 CFR 303.100, 42 USC 666. 1. See also the discussion of income withholding in Chapter 6. In addition, it is now mandatory to include medical support coverage in all new or modified support orders when it is available. 45 CFR 306.51b, 1, 42 USC 652, f. Jurisdiction. The authority to modify child support orders usually is based on the continuing jurisdiction of a trial court over the order. A decree of child support is always modifiable. 3 Reverend. Stat. 1979, ch. 40 par. 510. Moreover, a trial court generally has inherent jurisdiction to consider future child support in a dissolution proceeding and need not expressly retain jurisdiction. In Remarriage of Petramale, 58-3. December 537, 1021-3. App. 1049, 430 NE2D 569, 1981. This is true even where the absent parent no longer resides in the jurisdiction. See Carlin v. Carlin, 620 or.app. 350, 660 P2D 204, 1983, citing cases from Arizona, Arkansas, Colorado, Illinois, Louisiana, Maryland, Minnesota, Mississippi, New Hampshire, Ohio, and West Virginia. As a general rule, all orders are subject to modification, at least as the order applies to the future. Even where an agreement intended to be determinative was entered and incorporated into the final decree, the Supreme Court of Indiana held that this did not prevent modification, stating, "The fact that a child support order has been entered pursuant to the terms of a settlement agreement, even where, as here, it is now intended as forever determinative by the parties, is of consequence to the question whether the order should subsequently be modified. Meehan v. Meehan, 425 NE2D 157, Indiana. 1981. See also Burks v. Burks, 427 NE2D 353, 3 app.ct. 1981. Lacassaigny v. Lacassaigny, 430 SO2D 818, La. App. 5 Sir. 1983. Criteria. The general requirement for modifying orders is changed circumstances so substantial and continuing as to make the terms of the original order unconscionable. Uniform Marriage and Divorce Act, Sec. 316, A. The petitioner requesting modification is responsible for proving such a change in circumstances. In Remarriage of Roth, 55-3 December 271, 99 il.app.3d, 426 NE2D 246, 1981. In determining whether or not such a change has occurred, the relevant times are the date of the decree or the time of the last prior modification and the time of petition for modification. Strauss v. Strauss, 619 SW2D18, text.sif.app. 1981. Courts have reached various decisions about what constitutes a substantial and continuing change in circumstances. The major elements that have been used to differentiate such circumstances have been: which parties to the order are affected, what kinds of change qualify as substantial and continuing, and which standards can be used to evaluate the current order. Many jurisdictions have found sufficient justification for modification in a substantial change in the absent parent's financial position since the date of the current order. Our question, then, is whether a material and substantial change in both circumstances, the ability of the parent to contribute and the needs of the child, must be shown, or whether a material and substantial change in only one of the circumstances, the ability of the parent to contribute, is sufficient to justify modifying an order providing for the support of a child. We hold that a material and substantial change in only one circumstance, the ability of the parent to contribute, is sufficient to justify modifying an order providing for the support of a child. Holt v. Holt, 620 SW2D 650, text.sif.app. 1981. Other courts have held that an increase in the father's ability to pay is insufficient alone to justify modification. In Remarriage of Hughes, 635 P2D 933, Cullow. App. 1981. These courts have held that it is necessary to show not only that the absent parent's situation has changed but also that the needs of the children have changed. The parent, in seeking an increase, has a twofold burden. He or she must prove, a. the children's need for additional support and, b. the other parent's ability to pay more than the amount that was originally fixed in the order presently under review. Bates v. Bates, 448 UD 724, RI 1982. Emphasis added: to meet such a burden, it is often necessary to prove the needs of the children and financial situations of the parents at both relevant times. Flynn v. Flynn, 433 SO 2D 1037, Fla. App.4th dist. 1983. Generally, to justify a modification, the change in circumstances must be something that the court has not and could not have anticipated. Bylos v. Bylos, 441 A2D 59, Connecticut. 1981. This sometimes is based explicitly on the interpretation of the order and the principle of res judicata, which prohibits the relitigation of issues already decided. A Maryland Court of Appeals explains: any issue that was litigated or could have been litigated in the divorce proceeding may not be relitigated in a subsequent petition to modify the support. The basis of a petition to modify child support may only be an issue that was not and could not have been raised earlier, viz., a change in the circumstances of the parties. Rees v. Hupschman, 50 MD.app. 709, 448 2D 1109, 1111, 1982. What constitutes a change in circumstances sufficient to modify the order depends on the state. Colorado seems to lay the heaviest burden on the moved, that is, to show that the order currently in effect is unconscionable. In Remarriage of Anderson, 638 p2d 82, Cullo. App. 1981. In Remarriage of Hughes, Supra. Alaska has accepted the lightest criteria, that there was a change in the sense that there may have been a mistake in the assumption made when the decree was entered and that lack of sufficient funds to permit the custodial parent to do an adequate and reasonable job in providing for the best interests and welfare of the children was something which was both material and substantial. Hedlow up v. Hedlow up, 639 p2d 1010, 1013, Alaska, 1982. Most other courts have adopted a middle position on the issue, although the discretion allowed the trial court may lean toward one of the positions described above. For instance, a Missouri appellate court found that there was no abuse of discretion in failure to modify in the absence of evidence that the order was unreasonable. Henderson v. Henderson, 622 SW2D7, Mo.App. 1981. Generally, there is a heavier duty involved in establishing the need for modification if the obligation results from a voluntary agreement incorporated into the decree. Reese v. Hubschman, Supra, Bish v. Bish, 404 So 2d 840, Fla. App. 1981. Several other criteria for modifications also have been addressed. A common concern is the extent to which the court may take the passage of time, in itself, as constituting a change in circumstances. Williamson v. Chappell, 408 So 2d 134, Alabama.Sif. App. 1981, holds that the effects of inflation and increased needs of the children because of increased age justify an upward modification. See Vinson v. Vinson, 628 SW2D 376, Mo.App. 1982. On the other hand, a Colorado court has held that, although inflation is a factor properly to be considered in the modification of an order, the specific effects of inflation on the needs of the child must be shown. In Remarriage of Hughes, Supra, Carpenter v. White, 624 SW2D 618, Text.App. 1981, the increased age of the children is not, in itself, sufficient to justify modification. Other courts have held that something beyond the mere passage of time is required, although the discretion of the trial judge in specific cases is usually granted deference. However, an evidentiary hearing invariably is required before deciding that a modification is in order. In Remarriage of Smith, 641 p2d 301, Cullo. App. 1981. Trial court heard in reversing master without evidentiary hearing. A modification proceeding is a two-step process. First, the court determines whether a modification is appropriate, as discussed above. Next, the amount of the new obligation is determined. Brothers v. Vickers, 406 So 2d 955, Alabama.Sif.App. 1981. The criteria for determining the amount of the new obligation have been held to be generally the same as those which governed the establishment of the initial order. Once a trial court determines that there has been a substantial change in the financial circumstances of one of the parties, the same criteria that determine an initial award of alimony and support are relevant to the question of modification. These require the court to consider, without limitation, the needs and financial resources of each of the parties and their children, as well as such factors as health, age, and station in life. Hardesty v. Hardesty, 439 A2D 307, 311, Connecticut. 1981. See, however, in Remarriage of Anderson, Supra. Other issues relevant to the modification of an initial order include the obligations incurred by the absent parent toward a second family and whether earnings capacity, as distinct from actual earnings, is to be considered. Most courts explicitly consider the responsibilities toward a second family in assessing ability to pay increased child support, although these do not justify failure to provide adequately for the first family. Further, The subsequent remarriage of a divorced husband, as his own voluntary act, is not of itself a circumstance which justifies a downward revision of maintenance. While children of a second marriage can be a consideration in revising maintenance payments, we cannot unreasonably curtail or ignore the necessities or wants of the first wife and child. Viscosil v. Viscosil, 54 3 December. 873, 99th 3 App. 391, 425 NE2D 1090, 1093, 1981. Similarly, in Openshaw v. Openshaw, 639 P2D 177, Utah 1981, the Utah Supreme Court held that an absent parent's support of step-children is a factor to be considered during a modification proceeding. The effect of a substantial decrease in an obligator's ability to pay depends on the extent, nature, and cause of the decrease. Unemployment, or other financial downturn, does not entitle an obligor to automatic downward modification. Morris v. Morris, NW2D-10 Floor 1697, Neb. 1984. This is particularly true if the decrease in ability to pay results from the obligor's voluntary acts. He or she may not escape responsibility by voluntarily declining to work. Boyer v. Boyer, 567 SW2D 749, Mo.App. 1978, by deliberately limiting his work to reduce his income. Butler v. Butler, 562 SW2D 685, Mo.App. 1977, or by losing a job because of his criminal behavior. Nodin v. Nodin, 455 A2D 1051, NH 1983. In these circumstances, most courts will consider the obligor's earnings potential to determine whether a modification is warranted. Bylus v. Bylus, Supra, Johnson v. Johnson, 441 A2D 578. Automatic modifications. Attorneys and judges recently have begun to try to craft support orders that automatically adjust to changes in the parties' relative financial conditions, and for increases in the needs of the children that so often accompany their growing older. 247. These attempts have taken two forms: 1. Orders that are based on a percentage of the obligor's income, and 2. Orders that self-adjust based on changes in the Consumer Price Index, CPI, or some other measure of changes in living expenses. Percentage of income orders have not found favor in appellate courts due to their reliance on tax returns, pay stubs, or other poor reflections of the obligor's income, and because they do not account for other relevant changes, such as the needs of the children or the custodial parent's financial situation. Lewis v. Lewis, 450 SO2D 1123, Fla.dis.ct. App. 1984, in Remika, 272 NW2D 455, Lower 1978, Di Tolvo v. Di Tolvo, 131 NJ. Super. 72, 328 A2D 625, 1974, Brunner v. Brunner, 195 Neb. 143, 236 NW2D 846, 1975, Stanaway v. Stanaway, 70 Michigan. App. 294, 245 NW2D 723, 1976. Contra, C. Edwards v. Edwards, 99 Wash.2D 913, 665 P2D 883, 1983, and Heinze v. Heinze, 444 A2D 559, NH 1982. Orders that base the automatic adjustments on various factors, not merely the absent parent's income, have fared better. Courts in several states have upheld orders providing for adjustments based on changes in the CPI. Branstad v. Branstad, 400 NE2D 167, Indiana. App. 1980, in Remarriage of Stamp, 300 NW2D 275, Lower 1981, Orman v. Orman, 344 NW 2D 415, Minnesota. 1984. These decisions have noted that changes in the CPI provide a better measure of changes in the financial situation of all the parties to the action, that the CPI provides a readily ascertainable objective measure, and that such an approach enhances judicial economy. One major problem with both approaches occurs in states that automatically grant an unpaid support payment the status of a judgment when its due date passes. Automatic judgment status, discussed in Chapter 6, allows execution to issue without a hearing. The theory is that the amount of the judgment is readily ascertainable from the face of the support order, and thus a hearing would serve no useful purpose. Clearly, automatic judgments and escalator clauses are theoretically and practically incompatible.